Today, that is 24th April 2023, marks the completion of 50 years of the historic judgment given by the Indian Supreme Court in the case of Keshavananda Bharati versus State of Kerala. On this day, in the year 1973, a 13 judges bench of the Apex Court, by a majority of 7 to 6, propounded the theory of basic structure in order to apply certain restrictions on the amending power of the Parliament to change the Constitution of India. It is well known that right from 1950, that is from the commencement of the Constitution of India, till 1967, there has been no noticeable interference with regard to the validity of any constitutional amendment by the Supreme Court, probably because of the premise that Parliament has unlimited power to amend the Constitution. However, in another landmark judgment, in the case of I.C. Golaknath versus State of Punjab, rendered in the year 1967, which witnessed a challenge to the constitutional validity of the 17th Amendment. 11 judges bench of the Supreme Court, headed by Chief Justice Koka Subbarao, by a majority of 6 to 5, for the first time held that the fundamental rights are beyond the reach of the amending power of the Parliament. Justice Mudolkar, who was also a part of the bench, in fact introduced the concept of basic structure or basic features, though not in the same terminology in the same case, holding that the Parliament cannot amend the basic features of the Constitution. However, he did not elaborate this theory beyond a particular point. Then, naturally, the government did not feel that the judgment would do any justice to its constituent power to amend the Constitution, and Madam Indira Gandhi, who was the Prime Minister at that time, probably thought that there should not be any restrictions on the power of Parliament to amend any part of the Constitution. The consequence had been that 24th Constitutional Amendment was made, amending two articles, namely Article 13 and Article 368, to the extent that the law defined for the purpose of fundamental rights under Article 13 does not include the constitutional amendment made under Article 368, and further that Article 368 confers the power to amend the Constitution apart from laying down the procedure to amend. It was also categorically made clear under Article 368 that the Parliament has unlimited power to amend the Constitution or any part of the Constitution. This was challenged in the famous case of Keshavananda Bharati versus State of Kerala. In fact, this judgment rendered by the 13 judges of the Supreme Court by a majority tested the validity of not only the 24th Amendment but also 25th and 29th Amendments, etc. The argument on behalf of the government was that the Parliament has unlimited power, absolute power to amend any part of the Constitution. And there cannot be any limits imposed on this unique power, which can be called constituent power, which is quite distinct from ordinary legislative power. The argument on behalf of the petitioners was that there are certain features, you can call them essential features or basic features, which are beyond the reach of constitutional amendments. Therefore, these features cannot be amended. The Supreme Court took the view that both the amendments made to Article 368 and Article 13 under the 24th Amendment are valid constitutionally. The majority judges also appeared to agree with the contention of the Union government regarding the unlimited power of amendment. However, the turning point was in holding that though the Parliament has unlimited power to amend the Constitution, it cannot amend the basic structure or basic features or essential features of the Constitution. Those who are well versed with jurisprudence probably know that there is something called grand norm, the basic norm, which cannot be changed in certain laws. Similarly, you can say that every living organism may have a DNA that cannot be changed even by any mutation and all. Similarly, the Constitution also has certain basic features or essential features intended to remain in the Constitution forever as per the intention of framers of the Constitution. And 7 judges constituting a majority out of 13 judges through their few separate and concurrent judgments ultimately zeroed down on 11 features including parliamentary form of government, federalism, secularism, separation of executive from legislature and judiciary, and many other features totaling 11 features. And they declared that these are the basic features which cannot be taken away by way of constitutional amendment. Thus, the Supreme Court of India, by its master stroke, informally amended the Constitution by imposing restrictions on the Parliament to amend any part of the Constitution. And this basic structure theory has been getting expanded, interpreted liberally through the subsequent judgments, which challenged, or rather which witnessed challenge to number of subsequent amendments, and very strangely, even the laws enacted by the Parliament and state legislatures. Today, many of the basic features like judicial review, secularism, the balance between fundamental rights and directive principles, independence of judiciary, and many more came to be reiterated by way of number of landmark judgments. It may be of interest to know that after Keshavananda Bharati's judgment, as many as 75 amendments have taken place. Because today we have 105 judgments, and number of such amendments have been challenged on the ground that they violate the basic features. For instance, in Indira Nehru Gandhi versus Rajnarayan, the main issue was whether excluding or in fact not providing judicial review or taking away the power of judicial review in respect of election to the position of President of India, Vice President and Prime Minister, whether it violates the basic feature, namely the judicial review. 39th Constitutional Amendment was struck down by reiterating that judicial review and rule of law are basic features of the Constitution. Similarly, when we talk about 42nd Amendment made in 1976, which drastically amended the Constitution, was also challenged in number of cases, including in the famous case of Minerva Mills versus Union of India, and the amendment made to Article 31C, which proposed to change the relationship of fundamental rights and directive principles by giving total primacy to the non-justiciable directive principles to justiciable, fundamental rights, was struck down by holding that harmonious balance between fundamental rights and directive principles would be a basic feature and it cannot be taken away by any constitutional amendment. Similarly, we come across 52nd Constitutional Amendment, which introduced anti-defection law. And a paragraph of this, in fact, 10th schedule to the Constitution containing anti-defection law was struck down on the ground that judicial review was taken away by vesting the final power in the presiding officer of the concerned legislature to decide the question of defection. So are number of other amendments, whether it is 77th Constitutional Amendment made in 1995, which introduced Article 16(4)(a) to provide for reservations in promotions to the SC and ST government employees, or 81st and 82nd Amendments dealing with the relaxation from 50% maximum limit in case of backlog recruitment, or 86th Amendment, which introduced Article 21(a), that is the right to free and compulsory education for the children between 6 and 14 years. And very interestingly, even the 99th Constitutional Amendment, which proposed to replace the judicially created collegium system in the appointment of the judges of the Supreme Court and High Courts with National Judicial Appointments Commission. That was also struck down by a majority of 4-1 and in 2015, and the ground was that it would affect independence of judiciary, which is a basic feature. Similarly, 103rd Amendment, which provides for economically weaker sections reservations, was also questioned and it was upheld. The validity was upheld in the case of Janahit Abhiyan. And there are many such incidents, are the instances where number of amendments have been questioned, either upheld or got struck down on the ground that they violated basic features of the Constitution. Today, people are talking about the possibility of India becoming a theocratic country by replacement of secularism? Maybe only hypothetical question, but still they say that the basic structure theory would be a savior if anyone tries to make it a theocratic or religious state. Same may be the case with the other important features. The fact remains that fundamental rights cannot remain plaything of a majority, a political majority which may be even brute majority. Probably it was said by Dr. B.R. Ambedkar by reiterating the same in the Constituent Assembly debates. The same principle holds good for the sake of amendment of the Constitution also. Majority, whether it is brute or otherwise, in the Union as well as in majority of the states, have to respect the Lakshman Rekha, the dividing line, the basic structure or basic features theory. No doubt, it may be judicially created theory, or it may be equally true that judiciary stands to gain from some of the features identified as basic features, like the judiciary trying to take shelter behind the independence of judiciary as a basic feature to prevent an objective process of selection of judges of the Supreme Court and High Courts. At the same time, the fact remains that but for the basic structure theory, our constitution probably would have witnessed many more amendments. They would have destroyed the very essential features of the constitution. Sometimes maybe the politically ambitious class of citizens, they might use constitutional amendments to appease the voters and prospective voters, thereby forgetting the concept of constitutional morality, which must inform all the branches of government, executive, legislature, and judiciary. It is only the basic structure theory which has been the savior, which has been, in fact, a shield to the Constitution of India by protecting it from undue and unnecessary amendments during the last 50 years. At the same time, the tendency of the judiciary applying this theory not only to the amendments but also to ordinary laws also must be, in fact, curtailed to the extent that it is better to confine it only to the constitutional amendments. Today, about a dozen countries in the world, they follow the basic structure theory, taking a cue from the judgment of the Supreme Court in Keshavananda Bharati versus State of Kerala. Therefore, we have to remember, we have to commemorate the spirit of the basic structure theory, which is not a static theory, which is dynamic, which keeps on getting expanded. It is no more a myth. And we must always keep in mind that the DNA of the Constitution must remain the same. Appearance may be different. We can't, in fact, dilute majority of the objectives of the Constitution. Not the nomenclature, but the objectives as reflected in the preamble to the Constitution. The equality, the justice, the liberty, the fraternity, the dignity of individual. Only then, probably, it would be a good tribute to the concept of basic structure theory. Maybe the evolution of this theory owes its credit to great people like Nani Palkhiwala, who argued the matter, or great judges, the so-called 7 great judges. Not only the 7 judges, in fact, some of the basic features have been identified and also respected by some of the minority judges as well. H.R. Khanna stands apart in this particular process as a unique contributor. Be that as it may, I take this opportunity to greet all of you on the occasion of the golden jubilee of the basic structure theory, which affects the fabric of the supreme law of the land, which might affect every Indian citizen. Let us meet in the next video. Until then, let us celebrate the spirit of basic structure theory. Thank you.